Welcome to the Debrief, everybody. For those of you watching live on the Law&Crime Network, a last-minute plea hearing is happening as we speak in the case of former NFL player Kellen Winslow II. It appears to be putting him behind bars for 12 to 18 years and sparing him from a possible life sentence if he had been convicted on a series of sex crimes. There's a hearing happening live as we speak. Let's go in and listen.
Instead, your sentencing can be heard on February 19th. The year 2020, it'll be at 9 o'clock in the morning?
Yes.
Okay, we'll show a time waiver then to February 19th with respect to a scheduling for any filings that you might want to do. The deadline will be January 31st, 2020, the close of business. All written motions and supporting documents in support of your arguments for sentencing must be filed by January 31st. All responses are then due February 7th by close of business, and then we will have the sentencing on February 19th. That will be at 9 o'clock in the morning in Department 12 up here in North County. All right? What? 9 a.m. Yes, Department 12, 9 a.m. The defendant will be held without bail pending sentencing. Are there any further requests with respect to the plea?
No, Your Honor.
No? All right, let's bring in the jury.
These late developments in the case of Kellen Winslow II as the judge brings in the jury, that jury expecting to hear opening statements at some point today in this trial. They're getting called in and basically told there won't be a trial. We have the whole story put together for you right here on this broadcast of how we got to this point. Let's bring in our guests, though. Mike Koribanics in studio, Elizabeth Crotty in studio, Michael Bryant in the newsroom. So, Michael Bryant, you were in this seat up until this point. This has been a twisted road to get to this point.
Unbelievable, really. I mean, you know, the judge needed to find out if this waiver was intelligent, knowingly, voluntarily. How about unequivocally? I've never heard so many dramatic pauses when a defendant is asked if he's going to plead guilty as part of a deal. I didn't think it was going to come together.
Yeah, this seems like a pretty good deal here, Elizabeth Crotty. I mean, he's facing now 12 to 18 years. He could have been in prison for life if he had been convicted, if this thing went through to trial on the 6 charges that were in front of him today.
Yeah, I mean, it was the difference of 3 to 6 years, additional years, rather than he was already starting at 9. So it seemed like he wanted the deal. He didn't want to plead guilty. So it's kind of like he had to choose. And ultimately, he did plead guilty. But that was a real nail biter of a plea.
Oh, gosh. Yeah. I mean, we're sitting out in the newsroom, Mike Koribanics, waiting to see, OK, is this going to happen? Is it not going to happen? This broadcast starts at 5 o'clock. They finally accepted the deal. What was it? 4 minutes before, maybe 6 minutes before. And I said, OK, look, we're good to go here. Accuracy, of course, is the first word. But Mike, well, let's hold that thought. The judge is addressing the jury right now. Let's listen.
And what does that mean for you? It means that you do not have to serve on this case and that your jury service is complete. I know I've been admonishing you repeatedly. I know a lot of you started your jury service 2 weeks ago today, right? Some of you were here 2 weeks ago Monday, some of you 2 weeks ago Tuesday, and 2 weeks ago Wednesday. And I've repeatedly admonished you not to talk about the case with anybody, not to read any news accounts of the case, not to look at any newspaper articles. You are now released from that admonition because there is no need for a jury trial. Now, you might think to yourself, well, gosh, I just wasted 2 weeks of my life sitting around outside the courtroom and inside the courtroom asking questions that are very personal in nature about your background and so forth, to make sure that we could get a fair and impartial jury. We started with 172 jurors and ended up with 16. Both sides agreed that you could all be fair and impartial in this case, and I want to give you my thanks for being willing to serve on this case. There are, as citizens, there's only 2 mandatory things that we must do, duties as citizens. One is to pay taxes, and the other one is jury service. Voting is even voluntary. Military service is voluntary. But this is the one opportunity that you have as a citizen to fulfill your duty that does not involve writing a check to the government. that really fulfills your obligation as citizens. I want to tell you how much I appreciate that and how much I appreciate the time that you've taken from your day, away from your families, away from your jobs. Some of you who are retired, I'm sure you'd rather be out playing golf. We took time away from the golf course, but I really want to let you know how much we appreciate your willingness to serve on a case certainly of this magnitude and to try and keep your head pointed away from the TV set and the newspapers. So thank you again for your willingness to serve. You are no longer bound by my admonition. You can talk about the case with anyone you want, and the case is over. So your jury service is complete with the thanks of the court. So have a nice day. Thank you very much.
Okay, so all of those jurors seated in that courtroom in California as we speak probably want to know, why are we suddenly not hearing a trial in this case? We're going to recap what they're probably going to find out on their own as they go home right here on the debrief. Here's how this case started. 5 women accused the former NFL player Kellen Winslow II of a series of sex crimes. A jury convicted Winslow last summer on 3 counts and acquitted on 1 count. The jury was deadlocked on 8 other counts. Prosecutors today were going to try for convictions on 6 of the 8 counts. As to accuser number 1, this is going back to the original list of women who made accusations. As to accuser number 1, prosecutors were going to go forward on those charges right there: kidnapping, forcible rape, and forcible oral copulation. As to accuser number 2, it was sodomy by use of force. And as to accuser number 4, the jury was going to consider forcible rape and the rape of an unconscious person. There are, or I should say were, 2 additional outstanding charges regarding elder abuse, but the defense successfully convinced the judge to sever them from the retrial that was supposed to start about 45 minutes ago. This all went out the window with that last-minute plea deal that you watched here on the Law&Crime Network as to the original charges and 1 new charge. So before the plea deal happened, the defense fought to introduce evidence that one of the accusers had sex with her boyfriend and that he was the source of DNA revealed by a rape kit. This whole hearing earlier today gets into a critical area of evidence law, which specifically governs the use of evidence involving a purported victim of a sex crime.
To the victim's own admission, she had sexual encounter with an individual whose DNA was actually on her person, which was a consensual act. However, the injuries in this particular case were redness in the vaginal area and redness in the anal area, and they're non-conclusive. In other words, there's just redness. They can't tell what they mean, where they came from. The defense sought to introduce this testimony because the case law specifically has made allowances for this type of testimony when there's a possibility it's an alternative explanation for the injury. There is DNA of an individual, Bobby Guzman, who is her boyfriend. Mr. Winslow's DNA is not. In other words, she claims that she was vaginally raped and potentially sodomized by Mr. Winslow, and there's no DNA. The only DNA that Jane Doe 2 has on her person is that of Bobby Guzman, who apparently somewhere in the area between 1 to 4 days she had a sexual encounter with.
Okay, that's how the day started. This was outside the presence of the jury, and prosecutors admitted that Jane Doe number 2 had sex with her boyfriend 3 days before she was examined by a nurse after she reported she was assaulted by this defendant. But the state says that was consensual and different from what Jane Doe number 2 alleged against Winslow.
She specifically stated that that was penile vaginal intercourse and that other consensual partner's DNA was collected from her vaginal area, as well as there was a very, very low level of inclusion along her fingernail scrapings of that same consensual partner. Last trial, the defense attempted to get into that area of cross-examination with Jane Doe 2, and the court, I think, rightly precluded them from doing so because that's exactly what Evidence Code sections 782 and 1103 are designed to prevent. The possible spillover impacting the credibility of a sexual assault victim just by virtue of the fact that they've had consensual sex with a partner shortly in time prior to the reported sexual assault. Jane Doe 2 never reported and has never said that she engaged in any consensual penile anal intercourse with her consensual partner. Therefore, Mr. Mr. Carlos's offer of proof as to its relevance, I think, is lacking and should not overcome the presumption that any consensual sexual activity should be barred.
The defense went on to further argue that DNA should be allowed into the trial that now isn't happening.
It's not only just for the DNA, the sperm of Bobby Guzman that's found in her vagina, but it's also under her fingernails. So that goes to the choking allegations that she makes, which relates to the sodomy count, where she is pulling the fingers off of her neck, but there's no DNA of Kellen Winslow Jr. under her fingernails. Instead, what's under her fingernails is the DNA of Bobby Guzman. So if Your Honor, we're asking that the DNA come in for both the sperm of Bobby Guzman and his DNA, which is under her fingernails. The fingernails goes to the choking, which is in relation to the sodomy count, and the sperm is related to the penetration in the anal vaginal area.
Again, this is how the day started. The judge ultimately refused to allow this evidence of the other sex act into this trial, basically ruling from the original trial that original ruling would have stood, I should say, in the retrial. Here is the judge's explanation.
The court will stand by its previous ruling in the earlier trial. The evidence of the consensual sexual intercourse that she had with her boyfriend will be excluded pursuant to Evidence Code Section 782 and 1103. Especially at this point in time, given the fact that the forcible rape charge involving Jane Doe number 2 has been resolved, any redness in her vaginal area that may have been caused by consensual sex with her boyfriend is not relevant, because the only charge left with respect to Jane 2 is the act of forcible sodomy. So any redness in the vaginal area that may have been caused by the consensual sex with her boyfriend is not relevant, and what marginal relevance it might have is certainly does not survive a 352 analysis. There's almost no probative value whatsoever to that evidence, so it will be excluded.
Let's go back to our guests tonight, attorneys Elizabeth Crotty, Mike Koribanics, and Michael Bryant. So, Elizabeth, we heard the judge rattle off the California Evidence Code, which basically makes up that state's rape shield law. California's 1103 is like federal rule 412. Seems like a pretty clear-cut issue to me. A defendant generally cannot introduce a victim's other sex acts in a trial. This is pretty well-settled law.
Yeah, I mean, I think the judge made the right decision the first trial and the second trial. I don't think it actually had anything to, the ruling had anything to do with him pleading guilty today. I think because that Jane Doe number 2 had already been found to have been raped. I think the guilty plea came from the two outstanding cases between Jane Doe 1 and Jane Doe 4.
Mike Koribanics, do you agree with that? Do you agree that the defense losing this motion a second time didn't sort of like spur a strategy to go ahead and accept a plea?
I think there was a lot more to this plea than we know about, especially when the judge started speaking about, I've given you the lunch break, I gave you an opportunity to meet with your family. I think they pretty much knew where it was going, the ruling. A lot of times you do, but you need to preserve it for the record, and also in case it comes up if the door's open through other testimony.
Michael Bryant out in the newsroom for us tonight. The judge basically looked at the rape shield law and also looked at California's Rule 352, which is basically the same as a federal Rule 403. The judge can refuse to admit relevant evidence if it's too prejudicial. And that also makes sense here, looking at this hearing that happened earlier today, right?
Yeah, there's no doubt the 352 more prejudicial than probative. That was in play. But I think, and I disagree to some extent here, that I don't know that Kellen Winslow understood what that all meant, but I guarantee you when that ended and it looked like a loss, that it factored into his discussions with his attorneys to ultimately come up with a plea that he was, let's just say, reticent to explain to the court.
That's one way to put it, Michael Bryant. Look, I think that it probably, with all due respect to the rest of the guests, I think that it might have played a role in sort of spurring this plea on. But we're going to get there in a minute. Coming up next here on The Debrief, we're going to bring you back to that actual plea hearing with all of its pregnant pauses after the break. Let's start now with a check on other cases we're following here on the Law and Crime Network. One involves the retrial in the murders of 4 people, including 3 children. Is $20,000 in unpaid child support the motive, or is there a darker motive involving allegations the victim was involved with drugs and gangs? Prosecutors in Florida say Henry Segura murdered his girlfriend Brandy Peters, their 3-year-old child, and Peters' twin daughters in Tallahassee back in 2010. Segura reportedly owed Peters child support and was cheating on his wife with her. Segura's defense says he's innocent. They claim Peters was running cocaine for a Mexican cartel and skimmed nearly $100,000 off the cartel. The defense says the cartel ordered a hit on Peters and her children. A jury was hung in Segura's first trial after 19 hours of deliberations. Opening statements are expected tomorrow in this case. A sentencing hearing scheduled today has been pushed back to Wednesday for the young Tennessee man who pleaded guilty to killing an older man who he said had sexually abused his girlfriend. Court documents say 25-year-old Sean Foley faced a 3 to 6 year range for shooting and killing 44-year-old Jimmy Shelton. Foley recorded himself as he confronted Shelton during a sexual incident with the girlfriend. Foley said Shelton attacked him and that's why he fired. And moving on now, testimony has begun in the trial of a Colorado man accused of killing his fiancée last year. Patrick Frazee is accused of beating Kelsey Barrett to death with a baseball bat. Authorities say that Frazee asked Crystal Lee Kenny to clean up the aftermath. Kenny said she was in a side relationship with Frazee. Barrett disappeared after surveillance footage released by authorities showed her grocery shopping with her child around last Thanksgiving. 7 women, 5 men making up the jury. 4 other people are alternates. Cameras, live tweeting, and even a sketch artist are banned from the courtroom. Let's go back now to the Kellen Winslow II case out of California, where there was that dramatic turn late today where the judge walked into the courtroom and announced there was a plea deal. Here's how that went down. First, the judge asked Winslow if he agreed to the terms of the deal, and there was plenty of hesitation.
And are these your initials on this change of plea form?
Yes, Your Honor.
All right, before you signed and initialed this form, did you have a chance to read what was on the form?
Yes.
And did you discuss the contents of this form with your attorneys?
Yes.
Do you thoroughly understand the contents of this form?
Yes.
And were you able to thoroughly discuss the contents of this form with your attorneys?
Yes.
Right, and I know we've had a long lunch hour and you spent the last, well, about 2.5 hours talking to your attorneys, is that correct?
Yes.
Has that been enough time for you to make an informed decision about your decision today? Because the option is to go to trial. We have jurors out there waiting to start with opening statements in about 10 minutes. So have you had enough time to thoroughly discuss this with your attorneys?
Yes. Yes, Your Honor.
Okay. Well, I noticed you looked into the audience. I'm asking you. I'm not asking anybody else because, sir, this is your decision and your decision alone. I think you understand that. Have you had enough time to discuss this?
Yes.
Okay.
And now to the terms of the deal prosecutors offered to Winslow.
You are pleading guilty to counts 6, which is violation of Penal Code Section 261A4, as well as the added count 9, and the stipulated state prison term would be a range from 12 to 18 years. Is that your understanding of the plea agreement?
Yes. Yes, Your Honor.
All right, and also that you would waive your appellate rights with respect to the charges that you have previously been convicted on with respect to Jane Doe number 3, Jane Doe number 2, and Jane Doe number 4, which were reflected in the verdicts on June 11th of this year. Do you understand that?
That's Jane Doe number 5, Your Honor, not 4.
I'm sorry. That's right. Jane Doe number 5. You understand that?
Yes.
Okay, so you would be pleading guilty to 2 charges today, and the prior convictions from the first trial, those verdicts that were read on June 11th of this year would stand, and you would waive your appellate rights on those charges. Is that your understanding of the agreement?
Yes, Your Honor.
All right, you understand that the sentencing range would be a low term, the lowest possible term you could get is 12 years with a maximum possible term of 18 years, and you would present your evidence to the court. Mr. Owens would do the same, and then I would make a decision as to what the appropriate sentence would be, but it would be no less than 12 years and no more than 18 years. Is that your understanding of the plea agreement?
Yes, Your Honor, and I pray to God that you give me 12 and I can go home to my family as soon as possible, Your Honor.
Understand, and I will hear argument that your attorneys will make that would attempt to convince the court that 12 years is appropriate.
Okay, let's jump in with our panelists who are here watching this all go down. Michael Bryant in the newsroom. I'll start with Mike Koribanics and Elizabeth Crotty here in studio, though. Elizabeth, your clients behave like this when they're going into a plea hearing?
I mean, guilty pleas are hard, and guilty pleas in sex crimes are hard, and victim cases, they're very hard. He had obviously gone to trial, felt strong enough in his convictions to go to trial the first time, so then to come back and plead guilty the second time, it's a hard thing. I think to Monday morning quarterback it, no pun intended, I think his defense attorney should have done a little bit better of a job getting him ready for the plea, because that kind of hesitancy does not look good for anything. And if you're going to plead guilty, and as he said, I want 12 years, you know, you have to be a little bit more firm in your willingness to accept responsibility.
Yeah, Mike Koribanics here. We've got the defendant basically saying, well, I think I should be on the low end of the range. That's really not for today. That's really for another day in court.
That's really not for today. I thought it was poor timing. Once again, he's going to plead guilty, and he's making himself look like the victim. It's not a good optic, and it doesn't really sit well with the public or the judge. And right now, you got to impress the judge.
Michael Bryant out of the newsroom here. I'm trying to count all this up because what they did here is they got a guilty on doe number 2, a guilty on doe number 3, a guilty on doe number 5 in the original case. But here today we had a plea as to doe number 4, and I think the one that they added was for doe number 1, correct?
I just need a moment to think about that. Yes, as a matter of fact, that's right. They basically rolled all of the rape allegations as to Jane Doe 1 into a sexual battery with restriction for Doe number 1.
Exactly. So what I'm getting at here is basically prosecutors wrapped this up with getting some sort of a conviction or plea as to each of the 5 accusers. And I'm sure that's what prosecutors are hanging their hats on right now, saying, well, it took a while to get here, but we got a conviction or a guilty plea on every single one of the 5 accusers. You remember the phrase from the first trial, lightning doesn't strike twice, let alone 5 times. Thanks a lot to our panelists. That's all the time we have here on The Debrief. We'll be talking about this for some time to come, I'm sure. We'll see you tomorrow.